morning.
Good morning. So what's happening with this case?
Excuse me?
What is happening with this case?
So Judge, can I get a 30-day reset? I need to finish reviewing all the discovery. I believe this is our first setting.
All right, this is possession less than a gram case. Is there,
Well, there's also an assault case out of County Court 6.
all right, yes.
I would like to fire him, man. He's basically threatening me that it's a repeater up to 15 years or starting to 15 years.
Okay, here's the thing. I understand what you're saying. I do. And I internalize what you're saying. I don't know anything about your case. I don't know if there are priors or something that makes this a minimum of 15. I have no idea, because the only thing I know for sure that they have before me a case where you're charged with possession less than a gram. That's all I know.
That is a state jail credit.
Yes, it is. I mean, I know the range of punishment, but sometimes there are cases where there are repeaters. I don't know.
I am on parole right now as a repeater. So there's a mistake in that indictment.
Here's the thing. And I want you to understand, I have a role. Your defense attorney has a role and the state has a role. My role is to hear cases and make decisions on them. Whatever motion your attorney wants to file, your attorney can file it. If your attorney thinks the indictment is not correct, there's a motion to file for that. So
I have filed for a motion to suppress evidence and illegal arrest. Because the assault that I'm alleged of committing.
here's the thing. I don't have anything to do with your assault case because that's not before me.
Okay, I'm not signing on anything
Yeah.
for the possession
Mhm.
because the assault.
Here's the thing. I understand that this is your life, right?
Yes, it is my.
And
life.
you're trying to say a lot of things and you want to say a lot of things to me, but I want you to listen to me just briefly. All right. And then once I tell you this, if there's something you still want to say to me, you're more than welcome to say it.
Yes, ma'am.
All right. First thing, with regards to your attorney is appointed by a system called the will. And what ends up happening on the will is an attorney has to have specific qualifications to be allowed to be on the will to represent you on this state jail for felony. That's number one. Number two, the will has chosen this to be your attorney. So if you want another attorney, you'll have to hire one. That's number two. Number three, the only thing I know about this case is you're charged with possession less than a gram. You say you file motions. The person who has to file motions in your case is your attorney. Now, if your attorney, will you listen?
Yes, ma'am. Sorry.
Did I not say, listen to me? And then if there's something you wish to say, then I will listen. Now, your attorney is the person who's to file motions for you. If you have filed motions and your attorney wants to adopt those motions and have them heard, then the court will hear them. But that's where we are. Now, what would you like to say after I've said what I've said, and hopefully you've internalized it?
My question is, can you be trialed as a repeater twice?
Here's the thing. If you, and I'm not supposed to give you the hypothetical situations because I don't know all the facts of your case, but this is what I can tell you. If you end up going to prison and you went to prison as a repeater, the fact that you went to prison as a repeater, depending on the type of case, can be used to make you a repeater again. So, for example, let's say someone is charged with burglary habitation and they've been to prison before. And when they go to prison for the second time, they use that burglary of a habitation to make them a repeater. And let's say they sentence them to 20 years and they go as a repeater. And then let's say they come back and they pick up a new case and it's a new felony. And let's say that's a 3rd-degree felony. Let's just say it's a drug case. And that person has already gone to prison as a repeater. The state, if they want to, they can use that repeater that they've already gone to prison for, they can use it again. So the fact that you've been sent to prison as a repeater or as a habitual, and if you pick up new charges, they can keep using that same repeater paragraph that you've already went to prison for. So your criminal history is like a credit report. And you know how your credit report, sometimes stuff comes off your report within 10 years or 15 years. In criminal cases in Texas, they don't come off your criminal history report. It's there. So that's where you are. Now, mind you, I can't speak to your case specifically because I don't know it, and I'm not going to interfere with your relationship with your attorney. You understand?
Yes, ma'am.
All right, so Ms. Ferguson, on Mr. Guzman, I'm going to give you all a 30-day reset, and after that, we'll be headed to trial if that's what anybody wants. Ms. Ferguson, can I have a 30-day reset on Mr. Guzman?
I can do March 27th.
All right, so we're going to come back on March 27th. State, on Mr. Guzman, I'm going to need you to be prepared to make an offer before off docket before March 27th.
I mean, we can make an offer today.
All right, if you'll make an offer today, and March 27th then will be your plea deadline date. So the state is going to tender an offer to you, and you can make a decision on whether or not you want to accept that offer, Mr. Guzman.
Okay.
All right, thank you.
All right, thank you, Judge.
All right. All right. So, Mr. Villarreal, we're not on the record, but I see here that you haven't been reporting. Have you been using?
No. I'll come out clean.
Well, no, I mean, of course you're gonna come out clean. You're at the jail unless they're making drugs at the jail, which I know sometimes they do. But my concern is that you're not reporting. So if there's no reason for you not reporting, then maybe we need to go forward on the motion to revoke, and maybe you need to go to prison.
No,
Well, I mean, you say no, but according to this, you're not reporting. And we're not on the record. I'm not taking any of it as true. If we were to go on the record, I would keep an open mind, but I'm just going by what's on this motion to revoke. And probation, I take it very seriously. I'm not the person who placed you on probation, but you're not doing what you're supposed to be doing. And so what's the reason for that?
take it for granted, but now that I've been away from
No,
it,
how old are you?
33.
Nobody's taking probation for granted when they're looking at going to prison for 5 years, unless you're like 17 or 18 and you're just like, oh, that I understand, but your age, no. So why are you not reporting? And why are they asking for a TAP evaluation for you?
Yes, but I know, guess I'm taking it serious.
Here's the thing. You need to be honest with me. And let me just tell you why you need to be honest with me. Because I'm trying to set conditions so that you can be successful. I know your attorney wants you to be successful. Nobody here, obviously the state wants you to be successful. Otherwise, they'd be asking that you just be sent to prison. So there are limited resources and limited funds. So if you're telling me that you don't have a drug problem, there's no issue with drugs, guess what's going to end up happening? You're going to go back out in the free world and you test positive for drugs. I'm not going to be wanting to hear that. So why are they asking for a TAP evaluation and why have you not been reporting?
Yes. I really don't have a run up on life, Yes.
May I, Your Honor?
Yes.
I didn't have alcohol anonymous, but
All right, so why are we pretending like problems don't exist? Let me just tell you, everybody who has a motion to revoke file, obviously there's a problem. Because otherwise they wouldn't have a motion to revoke. Everybody who's on probation, obviously they have a problem because they wouldn't be on probation. Everybody who's going to prison, obviously they have a problem because they wouldn't be going to prison. So for probation to have filed a motion to revoke against you, that's telling me there's a problem. And what I can see in the motion to revoke, the problem is you're not reporting and you are an adult, you're in your 30s, and you're pretending like you're not taking this seriously. I mean, if you want to, today only, if you want to, I'll send you to prison for 3 years. If that's what you want.
61 more chance on probation, and if I fail, then I mean,
Well, I mean, do you want to talk to your attorney about that? Do you want to talk to him about that?
I just go one more try, you know what I mean?
Because I mean, otherwise, what's going to end up happening? They're asked that the motion to be withdrawn and that you be given a TAP evaluation in custody. I will allow him to have the TAP evaluation in custody, but it seems like he's going to say he doesn't have a problem, and TAP is going to say there's no problem.
I think that there may be some indicators for at least alcohol issues, Your Honor.
All right, this is what I'm going to want. I'm going to want TAP evaluation while in custody. Follow the TAP recommendations. If the TAP recommends inpatient treatment, We'll start with outpatient treatment. I'm going to want field visits 2 times per month. And the previous judge didn't put this in here. I'm going to want proof of employment within 30 days of release. There's to be no employment as a home health care provider or with minors. All right,
Thank you, Judge.
you're welcome.
May we be excused?
Yes, Mr. Villarreal, don't come back here. I'm putting a notation on this that you said you don't have a drug problem. And I'm also putting a notation down that I've addressed the not reporting with you. All right.
Yes.
My name is Happy. I upload courtroom video for education purpose. This video may contain copyrighted works not specifically authorized for use, but believed in good faith to be protected by the fair use doctrine under Section 107 of U.S. copyright law.